So today's topic is going to be on the effects of the proclamation of emergency on commercial contracts. So for the purpose of today's topic, we're not going to deal with the validity or the effect of validity or propriety of the proclamation of emergency, but rather we will deal with the effects that the proclamation of emergency has on in the commercial settings. So for today's topic, we're going to deal with two main questions. What are the relevant contractual provisions in determining whether proclamation of emergency could affect the performance of a contract? Second, how and when will the contractual provisions and the legal doctrine of frustration come into play? So in respect of contractual provisions, there are two most relevant contractual provisions which may affect the performance of a contract, and they are the force majeure clause and the material adverse change clause. So what are these clauses? For the force majeure clause, it is a contractual provision excusing a party from complying with its contractual obligations upon the occurrence of an event. There are essentially three layers to a force majeure clause. First is the specific events covered. It specifies events covered under the force majeure clause, such as acts of God, which would include pandemic, tsunami, and any natural disasters, for example, and government and legal measures such as proclamation of emergency. Second is the threshold. We will deal with this later on. Some force majeure clause does not even have a threshold prescribed in the clause. And thirdly is the option available to the parties once force majeure clause is invoked. Some of the options are suspension or termination of the contract. So force majeure clause typically applies where the agreements have been signed and completed and the performance of which is still ongoing. Whereas material adverse change clause is a contractual provision aimed at giving an exit mechanism or risk allocation mechanism to a party or purchaser if certain events which materially affect the said party occur. This clause typically applies where the agreements have been signed but have yet been completed. So some examples of material adverse change clause agreements which concerns material adverse change clause would be joint venture agreements which are subject to the procurement business license from the relevant authority, sale and purchase agreements which are subject to the permission being procured from the state authority for the removal of restriction of interest on a document title. This an example of it is the sale of Bhumi lot to a non-Bhumi purchaser. Supply agreements which are subject to an exit or suspension mechanism when there is a specified reduction in orders or loss of customers over a specific period of time. Material adverse change clause is also often found in mergers and acquisition dealings. In Satin Street Sensang Sunbing, started this last year, the agreement to purchase the shares of the companies in question are subject to a material adverse change warranty that the business of the companies has not been materially and adversely affected by the loss of any important client or resources of supply or by any abnormal factor not affecting similar businesses to like extent, and the vendors are not aware of any facts which are likely to give rise to any such effects. And in this case, the material adverse change was a diminution of or decrease in the sale of the companies. It is said to be a material adverse change which was not disclosed to the purchaser at the material time. So does proclamation of emergency give rise to the operation of the force majeure clause, material adverse change clause, or doctrine of frustration? So we will deal with this in turn. In respect of the force majeure clause, whether a proclamation of emergency can give rise to the operation of force majeure clause will depend on the construction of the clause. It may come into play if the clause states a mere proclamation of emergency is sufficient. So when it states that a mere proclamation of emergency is sufficient, there is no issue of threshold there. An example of which is where the clause says that the force majeure clause applies where government or any other legal measure taken to address a pandemic or to address a certain event. The issue arises when there is an added threshold. So this would come in. We will go into the second layer of the force majeure clause, the issue of threshold. An example of when the issue of threshold arises is when the clause will only be applicable if the event in question, i.e., proclamation of emergency, hinders, delays, or prohibits the performance of the contract. So when there is a threshold provided in the force majeure clause, the party intending to invoke the force majeure clause will need to prove that the proclamation of emergency, for example, has hindered, delayed, or prohibited the performance of the contract in question. When there is a threshold set in place in the force majeure clause, it is not sufficient for there to be a mere proclamation of emergency for the force majeure clause to apply. An example of this, of which you can refer to, is Section 3, Paragraph Sub 1 of the Emergency Essential Powers Ordinance 2021. It reads, for so long as the emergency is in force, notwithstanding any provision in the Federal Constitution, the Yang di-Pertuan Agong or any person authorized by the King may take temporary possession of any land, building, or movable property, or part of any land, building, or movable property, and may give such directions as appear to him necessary or expedient in connection with the taking or possession of that land, building, or movable property. Essentially, the provision says that the government can take temporary possession of any private property, immovable or movable. So an example of this is where, for example, a certain company is involved in the manufacturing, supply and manufacturing of a certain group goods, and those goods are produced or manufactured by a factory, and is located in a certain piece of land, and the government subsequently takes temporary possession pursuant to this provision, then it can be argued that the force majeure clause may be applicable at that instance. Note, however, that the termination of contracts which do not comply with contractual procedure and requirements under the force majeure clause may result in an action for wrongful termination. Such procedure and requirements include obligations to mitigate the impact of the force majeure event and to notify the counterparty of the occurrence of the force majeure event. So, as mentioned earlier, to determine whether or not there is such a requirement or procedure, one has to look into the force majeure clause in the contract, whether or not this procedure or requirements have been spelled out in the contract. Similarly, whether a mere proclamation of emergency can give rise to the operation of material adverse change clause will also depend on the construction of the said clause. The material adverse change clause does not even have to spell out specifically that the clause applies when there is a proclamation of emergency, so long as the proclamation of emergency could cause a substantial detriment to the performance of the contract or to any matter, the material adverse change clause may apply. So it doesn't have to state expressly that the material adverse change clause applies when there is a proclamation of emergency, as long as the proclamation of emergency could materially affect the operation of the performance of the contract, then it could be invoked. An example of this, although it is not in relation to a case concerning proclamation of emergency, is the case of Simpang Maju Enterprises and So Yan Ling, decided in 2017. The material adverse change clause reads, the bank is satisfied that as from the date when the borrower first applied the facility, there has been no material adverse changes in the financial affairs of the borrower, which could or might adversely affect the decision of the bank to proceed with or continue with the facility. As can be seen here, the event or the material adverse change is not really defined in, in the agreement. Nevertheless, the High Court held that the death of the deceased is definitely a material adverse change in circumstances, and in such an event, it is open for a third party to consider whether it wishes to continue with the agreement or to cancel it. So as mentioned earlier also, with regard to the example given in respect of the force majeure clause, if, for example, a company's factory is taken by the government pursuant to Section 3.1 of the Emergency Ordinance, the material adverse change clause in respect of an agreement for the sale of shares of the said company may come into play. So now we'll move on into the legal doctrine of frustration. So when you don't have any applicable contractual provisions such as the material adverse change clause, the force majeure clause, the legal doctrine of frustration may come into play. So the legal doctrine of frustration is codified in section 57 sub 2 of the Contracts Act, and it reads, a contract to do an act which after the contract is made becomes impossible, or by reason of some event which the promiser could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. So here, the threshold for the doctrine of frustration to come into play is much higher compared to the material adverse change clause and the force majeure clause, because the doctrine of frustration requires the act to be impossible to be performed, or at the very least unlawful. And according to the Court of Appeal in the Hong Leong Bank and Tan Siu Nam, said doctrine may arise when the following occur. There is physical or literal impossibility to perform a contract, or the performance of an act may be impracticable or useless from the point of view of the object and purpose which the parties had in view, and if an untoward event or change of circumstances totally upset the very foundation upon which the parties rested their bargain, it can be very well be said that the promiser found it impossible to do the act which he promised to do. So note that as the threshold is higher, a mere delay in performance alone is not sufficient to give rise to the operation of the legal doctrine of frustration. So in conclusion, there are 3 points that can be summarized here. Firstly, whether contractual provisions such as the force majeure clause or material adverse change clause can be invoked once emergency is proclaimed depend on the construction of the said contractual provisions. In the absence of any applicable contractual provisions, the legal doctrine of frustration may apply. And lastly, the legal doctrine of frustration will only apply if the performance of the contract is impossible or unlawful by virtue of the proclamation of emergency. That's it for today's topic. If you have any questions. If you have any questions, feel free to drop an email to me. I will do my best to answer it in due course. Thank you, everyone.